Вітаю, шановні колеги.
Welcome, dear colleagues, members of the public, and warm welcome also to the candidate. Today, the advisory group of experts convened in full composition to conduct an interview with the candidate for the position of Judge of the Constitutional Court of Ukraine, Madam Nataliia Denysenko. He is the Deputy Head of Department of Comparative Legal Analysis, Head of the Department of Comparative Studies of the Legal Department of the Secretariat of the Constitutional Court of Ukraine. And she was admitted to the competitive selection process by the Council of Judges of Ukraine. And the purpose of this interview is to clarify some issues which are related to the assessment of the high moral qualities of the candidate. I will pass the floor now to the Secretary of the AGE, my colleague Mr. Romaniuk, to moderate that interview. Please, the floor is yours.
Дякую, пане голово.
Thank you, dear Chairman, dear Natalia, dear participants. So I would like to say that present are members of the advisory group of experts, the Alex Zala, the chairman, Ms. Hanna Sukhotska, Ms. Marine O'Connor, Ms. Natalia Kuznetsova, Ms. Oksana Vasilchenko. Also, there are deputy members of advisory group of experts, Thomas Bell, Griffith, Richard Barrett, Marek Zubik, Vasil, and Volodymyr Kuzbenko. And me, Yaroslav Romaniuk, the secretary of the advisory group of experts. Let me briefly explain the goal of this interview. We worked for a long time and we gathered and collected information about you. We're grateful for your information presented and your answers to our written questions. We obtained a lot of information. We have a lot of positive information and we are really glad. But there are some questions that we would like to clarify to give you the possibility to clarify some doubts that we possibly could have to your correspondence to the criteria of high moral qualities. I would like to say that we won't take into consideration documents and information that we have asked you preliminarily and you haven't done it. Or maybe some information that you are ready to provide voluntarily, but you haven't provided them. However, we can make an exemption if we have some justified reasons. So, I also want to emphasize that the duration of the interview is approximately 1 hour, and the regulation for answering questions is up to 3 minutes. Please address it concisely. In the end of the interview, you may make a brief closing statement up to 5 minutes. Is it clear? Our international experts will communicate in English. If you need, you can use the headset for simultaneous interpretation into Ukrainian. Now we're ready to start, and I will start it by myself. Ms. Natalia Mykolaievna, before starting to work at the Constitutional Court of Ukraine, you worked in a limited liability company. Then you had a gap in your working experience. After it, 1.5 years, you worked as a lawyer in one of the banks. Can you tell us how, with such a concise legal background, you manage to take a position in the Constitutional Court because there are selection procedures. It's quite a difficult process. Thank you. Good afternoon. Glory to Ukraine. Glory to heroes. Before answering this question, I would like to say that I worked in institutions that you mentioned when I studied at the university. So I combined my studies with work. But the essence, how did you manage to obtain a job position in the Constitutional Court? So I hope it will be interview, not just answers questions. So I started to work when I was in education. After having higher legal major diploma, and this is the basics to be admitted to any state service. So after, I was offered to work in the Secretariat of the Constitutional Court. Who offered you? One of the judges. Unfortunately, he passed away. Was one of the judges of Constitutional Court. So there it was the stage of formation of Constitutional Court and Constitutional Secretariat, and the Scientific and Analytic Department was just at the state of formation. And one of the requirements was the knowledge of foreign language. That's why I was offered this position, because I studied French language in a specialized school. In the institute, I studied French also and English. And having two languages, I was offered this job to work in this department. Ms. Nataliia, do we understand correctly? In that period of time, when you were admitted to the Constitutional Court, one of the judges was Mr. Martynenko Petro Fedorovich. He was also the co-advisor of your PhD thesis. Do we understand that he favored and invited you to work in the Constitutional Court? He offered such a position, but from the time of his offering and to my appointment, more than half a year passed. So I passed through different interviews. There were no selection procedures during this time. There was only interview. And I was admitted as main specialist, and I worked for a year as a main specialist without any payment rises, because I didn't have any experience in state service before. That's why I worked in this department without any pay rises. What are your job responsibilities? I am the head. So I'm the deputy head of the main department. This is more administrative, but now I'm the head of the comparative research department. So I should prepare, and my department prepares analytical information materials. As for comparative studies between international and foreign legislation, practice, and good practices of the European Union, of human rights courts. And all these are asked by the judges who consider different cases. I understand your question, and very often judges of the Constitutional Court take part in the international events. Ms. Nataliia, please. Okay, so we found out what are your job responsibilities. Information that we possess gives us opportunity to ask, because when we talk about integrity, and one of the criterion of integrity is your job responsibilities. So information that we have gives us acknowledgement that for 10 years of your work, you have done 49 analytical conclusions. Tell me, please, is it a high index about your responsibility. I don't know why, or I know what is the background of this information, but I would like to say that there are moments when I prepare the statement or my employees, they prepare the statement and I just control the execution. So there is the difference between what I have done by myself and what I have just controlled. So it means that sometimes in subscription of the document, we have a person who translated this document. So the documents when the end executive is not me. I mean that you have conducted more work, but it was mentioned that this work has been done by other people. Yes, okay, maybe. But since May 2015, I have just started to work. And since 23rd of June 2013 until the May 2014, I was on the sick leave, I was on the leave. So for a year, I was absent during my work. So we can count 9 years, not 10. Okay, thank you. Natalia Mykolaievna. So since 2005, you have held the same position. Tell us, please, why there is no promotion? Or maybe you refused, or maybe you were not offered the promotion. At first, I refused. So I was offered quite a high position in the secretariat, but I refused because I had my personal reasons for that. After, when I started to work in the departments which I became head, there were only 2 people. I had to raise and to develop this department, and I did my utmost to make this department work. I thought it would be very inappropriate just to leave one person in this department and to go up to the career ladder. And I have already written. Jean Monnet said that we shouldn't be ambitiously, but we should act ambitiously. So that's why, yes, I have been offered such positions, but I refused. According to the law, there are 2 scientific consultants and vice assistant as judge. So haven't you considered such possibility to gain such position? I think that the background on such a position can be more relevant for the further constitutional court judge. Yes, I have obtained such offers, but I understand that being under one head, this is quite another thing. So now, for example, 13 judges can address me. For example, if I have only one patron, he or she will address me unanimously. Moreover, I'm a civil servant. I got used to the fact that I am guided by the same duties, responsibilities as the patronate service, but not for one patron, not for one chief, but for a couple of people at the same time. It is clear. Miss Natalia, you said that you foresee the question, and maybe this is the question that you hope to obtain. Do you have experience in preparing drafts of court decisions? I have never prepared drafts for constitutional court decisions. It is prohibited for such servants, so I don't have such background, and it cannot be there. Thank you. Another question. In your motivational letter, you stated the following. You said that you feel that there is a lack of judge practitioner, but you are not a judge. Why do you think that personal composition of constitutional court will be enhanced For example, you say that the judge practitioner is needed, but you are not such a person. I mean, not judge practitioner. I mean, just a practitioner, because we have a lot of theoretical specialists. So you mean it's not about academician, it's about lawyer practitioner. Well, I wouldn't say that it must be a lawyer practitioner, because lawyers, practitioners, they don't know the peculiarities of the constitutional proceedings. You know, there are a lot of patterns and nuances, and judge and lawyer practitioner. So I see it, I feel it just seeing the document, that for me, practitioner is a person who knows not what is written in the law, not on what is written on the codes, but such person understands what were the reasons for the Constitutional Court to make such a decision, what was the basics, not in theoretical, but more in practical aspect. It is clear. Natalia Mykolaievna, you said that you are fluent in English and French. I will give the floor to English-speaking participants, Ms. Maureen O'Connor, and I would like you to answer these questions in English. I said that I'm not fuel in English. I possess the knowledge of English and French. French is my first language. So for French language, I can answer without any problems. English language is more for reading, so I know how to write in English. I can translate. I can answer, but there will be some problems with pronunciation. So it is easier for me to communicate in Ukrainian. So I possess the knowledge of such languages. I know Russian and Arab. So you said that now you are studying Arab. Yes, I am studying the Arab language on the level A2. Okay, you say that it is easier for you to speak Ukrainian. Okay.
Good afternoon. Thank you for appearing before us. I was looking forward to having an exchange in English, but I appreciate your honesty that your spoken English is not as good as your written English. That makes a difference when we're in this format. So let's proceed. All right. I am, in your letter of motivation, I found this to be very interesting. You stated that, quote, I'm not interested in either the level of remuneration of the judge of the Constitutional Court of Ukraine or all the advantages of the status of a judge of the Constitutional Court of Ukraine. After all, I perform similar work while holding my position as head of the Department of Comparative Research. However, only a judge has the right to prepare a draft act of the Constitutional Court, participate in the discussions, and most importantly, vote for the adoption of the act. Can you explain why you're not interested in, the part of, being a judge of the Constitutional Court when it comes to remuneration and status? Explain that a little further, please.
Дякую за запитання.
Thank you for your question. As for remuneration, I know it. That's why I can tend to achieve this level. But I'm not so stick properly to remuneration issues. And for me, the process is more important. When I prepare the documents on the request of the judges, it is very important for me to study and find out what are the basics of this topic or declaration. And sometimes in oral form, I just communicate and discuss it with the judges about the questions. So the status of a judge is important and essential, but I know my work and I understand that it is also very paramount, but judge has quite a high status.
But you would agree that what I hear from you is you're not motivated by money, right? You're not,
Tak,
okay.
tak, tak.
You would do the job for free. I'm just kidding, just kidding. Never mind, that was a joke. That was a joke.
Може.
Okay. So I can understand that, not motivated by money, and the status either. Okay. So, but can you explain how you perceive the similarity between your job, your current job, and the work of a judge of the Constitutional Court of Ukraine, and how it relates to your direct job responsibilities? What do you do now that you would do and enhance the role of the Constitutional Court judge?
Подібність полягає в тому, що
Well, the similarity lies in the following. The judge, or when I get the constitutional complaint, we start working on the documents. The judge works with his own specifics, I have my specifics, but when I often talk to him, we can find very useful arguments for opening the proceeding, for example. So this is the basics. The opening of the proceeding or refusal to open the proceeding. Later on, when the case is open, we have special reasons to refer to me, and the judges refer to our unit where we study the specifics. Perhaps even those referrals or application that the applicant couldn't trace in his application. And sometimes it even happens in the latest decisions. The judges of the Constitutional Court use our documents, and they serve as the basis, and they refer to them based on the so they use them as foundation for the decisions, even for the European Court of Human Rights, and I would like to thank that for that.
So you said the complaint comes to the court, and I'm presuming you and the judge's clerk and legal advisor look at that complaint and decide whether it's worthy or eligible to be heard by the Constitutional Court. Am I correct on that?
мій
My division does not do this. This is the responsibility of another division, and they give the grounds. But it is possible that the judge doubts whether or not to open the proceeding, and he or she already has the text or the wording where it says that they have to open it or refuse, but the judge may doubt it, so he wants to know the practice of the constitutional courts of foreign states or some international acts that can enhance his position as the rapporteur. Or it's also possible that it's the EU court can specify some elements, and the judge refers and asks us to provide him this information.
So basically, you work at the direction of a judge of the Constitutional Court. You're not independent in what you decide you're going to research and provide information on. It's purely at the direction of a judge.
ну, щоб у вас не склалося як
Well, to avoid any misunderstanding, the judge, the rapporteur, gives me the request, and he doesn't tell me what way I have to tackle this, but he motivates me to explain some elements.
All right. So then we look at what you do, and we look at the role of the Constitutional Court judge, you know, you do research, you give comparison with EU law and et cetera, give them a basis for one direction or the other direction. But you don't have the ability to vote on cases.
Tak.
You're an advisor at this point. So is the ability to vote for the adoption of an act of the Constitutional Court a key argument here and motivation for you to acquire the status of a judge?
Perhaps, because participation in the sessions, court sessions, can only be given either to the judges or to the participants or parties to it. And if it's a closed hearing, that only the participants of the Constitutional Court can be participants. And I find it very interesting as a lawyer because it serves as the basis for the decisions of the Constitutional Court.
All right. Considering your explanations, you position yourself as a practitioner with the necessary practical experience for the position of judge of the Constitutional Court of Ukraine. However, based on the content of your job responsibilities, your experience is such that you organize and you prepare analytical materials. And so can you provide real examples of your practical experience where you would, in essence, use the same type of judgment that you would use as a member of the Constitutional Court? Do you have any experience doing something like that?
Не зовсім
I didn't quite understand your question. Could you please dwell on it?
Well, I apologize. So you are, you've outlined your experience. You've discussed what your job responsibilities are. You've talked about the fact that you are directed by a judge, maybe more than one judge, to research and give them a comparative perspective on the law in other jurisdictions, something they can utilize, something that will inform, and then they make a decision, okay? And based on your job description, which we've just discussed, your experience is limited to organizing and preparing analytical materials. I'm not taking anything away from that. Judges could not function if they did not have, great resources and support. But provide real examples of your practical experience. And I don't mean being able to do an analytical analysis of EU, just in your experience, both where you work now and maybe previously, real examples of your practical experience.
You're asking the question I fear to answer, because for multiple occasions at the previous competitions, all of my answers to such questions were taken by other persons and were used in their activity. Mainly, and I will tell you, in the Constitutional Court, there is such a catalog of the legal positions of the Constitutional Court. I was near the first sources of this catalog. I use it as the thesaurus of the legal positions in the court. Everybody knows that I have developed it, that I developed it in accordance with the Venetian Commission, and later on it was used as the basis for legal position of the Constitutional Court. No claims for people who have altered it. I do this work as a civil servant. I have no right for intellectual property for this work that I do. I gave this work away. Please change it if you need. So now I am also still completing it, and I have a few developments, actually two, that confirm me as efficient practitioner in reference to the constitutional complaints. So on the elements of unacceptability of the constitutional complaints. All lawyers fight for this in Ukraine because the Constitutional Court rejects on certain reasons, but they do not specify which ones. No lawyer knows the exact reasons. These are generalized reasons, and I work on the detailization.
So you have then a catalog of cases that were
Так.
rejected as well as accepted, and you have annotations on each case to determine why they were rejected or accepted. Is that an understanding, or am I incorrect on my understanding?
I have, yes, such a thing, a catalog of the positions, and it's just that it's adapted to the Ukrainian legislation. On the website of the Venetian Commission, there is the thesaurus of the constitutional courts, and there are certain sections. And I have also prepared the one for Ukraine based on that one. And I have also developed like a guideline for grounds of unacceptability of the constitutional complaint in Ukraine. But this idea, or such ideas, there was a very good word once that's plagiarism of ideas. And this is used after each competition for the position of the Constitutional Court. This is very often done. That's why I am very reluctant for this to be used further on, because this is my development, but they know about this in the court. This is a known information for the judges.
Is it on the court's website? Is it something other people can refer to?
Ні. Це
No, this is the catalog of the legal positions is on the website, but I'm the only owner who have this thesaurus. It changes from the catalog. It has certain nuances that I cannot discuss at the moment.
Right. Okay, we'll move on. In response to your question asked about by the advisory group of experts, quote, do you consider yourself to be part of the scientific community? You gave a relatively short answer, basically, no. However, during previous interviews for the position of judge of the Constitutional Court, you indirectly referred to your PhD status as an advantage. Is it an advantage? And if so, how?
на перевага є, була.
So the advantage was when I came to work in 1998 to the department of the analytical department, it used to be named. It could only be headed by the person who had a degree. This was one position, the Secretariat of the Constitutional Court, when the requirement was to have a degree. Later on, when I got the degree and when I had the thesis ready, they offered me this position. Until 2016, I could say that so there were the restricted number of the candidates of sciences, and that's why it was an advantage. But now we have more people who have PhD.
Use the results of your thesis research in your professional activities now. Is that a fair statement?
I did, because my topic referred to a combination of the international law and the constitutional law. The topic of the thesis was the application of the norms of international law by the bodies of the constitutional jurisdiction. And now, as of the decision of 1999 about the abolishment of the death penalty, And there we had some fundamentals or bases that I had in my thesis. And then it was the Rome Statute. And now you can see almost in each decision of the Constitutional Court elements of the International Court and the European Court of Human Rights and all the acts referring to the status of the judges. We recently had the restrictions as referred to pandemic, and in the one of the latest one on the rights of the consumers, there they used the decision of the directive of the European Parliament. And if I hadn't studied international law, if I hadn't degree in the international law, it would be very difficult to study the international legal acts because they have their own specifics. So for me, that's a natural thing when I study these moments. I used my knowledge in international law and in what I have studied and analyzed in my thesis.
Defend your thesis. When was that?
Вчора
I have celebrated the 20th anniversary yesterday.
Congratulations. I would think that when you wrote your thesis, as insightful and academic and maybe innovative as it was 20 years ago, that your experience over the last 20 years gives you a much better understanding of comparative and international law as it relates to Ukrainian law than what you knew 20 years ago. I mean, 20 years ago, you might have been doing baby steps compared to what you're doing now. Is that fair?
так.
Okay, all right, good. Moving on. During one of the previous competitions for the position of judge of the Constitutional Court, you stated, quote, "Often I write, let's say maybe unofficially or maybe officially, that judges give me assignments and I write reports on behalf of the court." Excuse me. "I also personally prepare various documents because I am a candidate of science." The quote suggests that you directly link the assignments given to you, which are not within your job description according to the position's instructions, precisely to your PhD status. But I think we went over that. It's not, or maybe let's do this. Can you elaborate on what you meant by that statement?
I made this statement until the amendments were made to the job description, because until now my division has prepared the reports for different international events where the Constitutional Court participates. Given that these international events are rather specific, mainly, as an example, well known to everyone, the Congress of the European Courts, KEX. This event is held once in 3 years. The topics are selected by the courts where this event is held. So, for example, one of such was Batumi in Georgia, and the topic was the explicit and implicit powers of the constitutional judges. So the lawyer or the practitioner who works in the Constitutional Court not for a long time, it would be very difficult for them to go through, to navigate in this topic. So they suggested me to prepare the, report on this topic. And since we have judges in our court who have experience of work abroad in some international offices, so they also helped me. I could refer, to them with this assignment. When I prepared this assignment, the chair of the court had certain doubts, and he gave this report to one of the judges of the Constitutional Court, and after he studied it, he made his assessment, and then it was, on behalf of the Constitutional Court, it was referred to Batumi as the national report on behalf of the Constitutional Court of Ukraine.
adopt, the Constitutional Court of Ukraine adopted what you had researched, compiled, analyzed, and then presented the document. And it was reviewed by all members of the Constitutional Court? Okay.
Ні, одним суддею.
It was reviewed by one judge from Constitutional Court. He was an expert. He wasn't here like a judge of Constitutional Court. He was here just as an expert because he had qualification of a lawyer who knows national and international legislation, and he possesses the knowledge of foreign language. There were some nuances in the questionnaire of the Congress of European Constitutional Judges because we there had to state some moments from Ukrainian legislation, and the practice of Constitutional Court was ambivalent at this period. Moreover, I cannot submit some things for public. So the information that I have presented, I can present, but whether it is possible to be disclosed, I don't know. That's why the chair of the court said that there must be an expert who will review it.
All right, thank you. Thank you. No?
Шановні колеги, чи можливо в когось іншого є запитання?
Dear colleagues, maybe you have some other questions to the candidate Denysenko? Now,
Question,
Так, будь
Secretary.
ласка, пан Залер, голова дорадчої
Yes,
групи.
thank you. Madam Denysenko, it was very interesting to hear about a guide you are developing on admissibility of constitutional complaint. Is this your personal idea to develop such a guide, or you was asked by any judge of the court?
Ні, це особисте моє.
this is my personal idea and a wish, and during my personal work, it wasn't about the work in the Constitutional Court. Sometimes it was done besides my job functions.
In this guide, do you use as a source a published decisions of the court, or you use also sometimes also the confronted arguments among judges when they're having the deliberations on certain matter?
Ні, це ті.
No, it's only about the rulings and decisions of Constitutional Court. I will explain. My job functions include preparation of the ballot of constitutional jurisdiction of Venice Commission, and there is a summary of decision. I prepare the summary of decisions in Ukrainian, then international department translates it and sends to Venetian Commission. So when I review the decisions of the Constitutional Court, then it is better for me to put these decisions into different slots of my guide.
Okay, but this is not available to judges of the court, or is it?
So there is a catalog of legal positions on the website of Constitutional Court. When I suggested my guide, I didn't have proposals to substitute this catalog with my thesaurus. Some judges can use it because judge can approach me and can ask what and how is it going. Maybe he or she has some doubts about his or her material, so it is not prohibited in the court. I have clarification question. what is the difference between your thesaurus and the catalog of legal positions of the Constitutional Court? So you constructed your thesaurus due to the definitions, categories of cases, etc. So I understand when we talk about thesaurus, it is more about some database or something like this. Catalog of legal positions is prepared based on different categorization of cases, terms, etc. So what is... I haven't seen it, so I want to understand what is the relevance between this, your thesaurus, and the catalog of legal positions on the website of the Constitutional Court. I'm interested in it as academician and researcher because you talk about it so much that I'm willing to see it. Or maybe you can explain more in detail why your guide is useful for the users of this material. So you said it correctly, for users. When the catalog has been elaborated, I participated in it not directly. I mean the catalog on the website. I was involved. Some positions, some criteria were not acceptable for me because they were a bit, I can't say that based on Soviet Union, but they were not appropriate to modern characteristics. Can you give an example? For example, what I would like to hear from you. So just to understand, give us at least one example, so to understand what is the difference and what are similarities. Okay, example was, for example, there was distribution as for spheres of law. Were there in the catalog? You understand that spheres and sectors of law, it's not a modern term. So, and your guide, what are your criteria? My criteria are criteria by the Venetian Commission. For example, at first, they have very interesting distribution on different sections. The first section is constitutional justice, where there are all the elements that we research. For example, composition of constitutional court in different countries, the status of constitutional court separately. There is such criterion as human rights in European. Yes, it is clear. What else? What other subsections and sections do you have? How do you collect the information? Because, okay, law, spheres, and sectors I understand. Then, what can just appear now, and I don't know whether it is in the catalog, because I don't lead this catalog. In my thesaurus, there is a criterion as armed forces or law enforcement forces. Separately, there are local authorities. But it's not just about local authorities, because this doesn't exist in Europe. Thank you. Thank you, Ms. Natalia. Now I understand more clearer what we're talking about. Ms. Sukhotska, please, a question.
Very carefully what you said on your role in the Constitutional Court in Ukraine. And you mentioned several times that you prepare some information in line with the Venice Commission guidelines, rules, yes? So I would like to ask you more clearly, more deeper. Did you prepare the information which are published in the Bulletin on Constitutional Case Law by the Venice Commission? Because Venice Commission published such a e-bulletin on Constitutional Case Law. And there is a list of presses by country. And I found exactly a very rich list of the information coming from the Constitutional Court in Ukraine, yes? So I would like to know what is your role in making preparation this information, yes? Because it is exactly very useful for many around the world, because it's published in English and is open in the internet, yes? So I would like to know, it was also your role to make input to this bulletin or not, yes?
Дякую за запитання.
Thank you so much for your question. As Mr. Romanuk asked, What are my job functions? So in this aspect, you can't see my contribution. In the list of the requests, it is not seen that I have done it because communication officers, there are 2 of them. But frankly speaking, what it is done in Ukrainian, summary, answers to the question of other constitutional courts in Ukrainian is done or by me or by my employees. Then international department translate it, and then as communication officers they send it to the Venetian Commission, and they are subscribed as executives who have done it, and not me. But the summary of the decisions I have been doing since 1991 when Martinenko was a communication officer. Why? Because then only judges were in such a position. Today communication officers can be assigned as any person assigned and appointed by the Venetian Commission. Unfortunately, we were not offered to become communication officers. But when there are requests from the constitutional courts of international level and in other countries, I present also the answers in Ukrainian.
Ще одне запитання.
Miss Natalia, another question to you. When we look in your motivation letter, you said that you see your role in the restoration of the post-war Ukraine in conscious participation in the competition for the position of a judge of the Constitutional Court of Ukraine and a real vision of what needs to be improved and developed in the activities of the Constitutional Court of Ukraine. However, your motivational letter doesn't reveal your vision of what exactly needs to be improved and developed. We suggest you provide an answer to this question. So what should be improved? Since 2016, when there were the first selection procedures and competitions for the position of Constitutional Court judge, I talked a lot about the reforms that should be implemented. Before 2016, I had been involved very often, not formally, but Constitutional Court has never been a subject of legislative initiative. But through some persons, we could offer some reforms on behalf of the Constitutional Court. So in this case, the reform of Constitutional Court appears to be visional in the other approach to the constitutional claim. And what is the problem to change the approach? What do you mean? Please be more concrete. In the list of the reasons of the rejection, you will see only general ones. But the Constitutional Court, as you see in the rulings, refers to some more detailed reasons. So maybe they should be introduced. Moreover, now there were a lot of issues. As for collective constitutional claim and complaint, it takes place in some countries. But we have different approaches. Some people say it is acceptable, some people say no. So at least these moments, to simplify the submission of the constitutional claim. For example, one of the judges of the Constitutional Court suggested a kind of questionnaire or a module. Why this module cannot be introduced on the legislative level? It exists in a lot of countries. So as far as we understand, you see the possibilities of improvement of the mechanism of constitutional claim and complaint. In your opinion, what was the goal in Ukraine to introduce the Constitutional Claim Institute generally, and whether it was achieved? I think the goal can be stated by the legislative officer, but for me the goal was to give opportunity to ordinary people and civilians to address about the violation of their constitutional rights, but it hasn't been achieved 100% because it all passes through the legislation system of Ukraine. If we had implemented in a larger context this constitutional claim, if we had had possibility to pass to the complete constitutional claim, it would have been better. But then we would have had more work. Colleagues, do you have any other further questions? Okay, Ms. Nataliia, we are ready to wrap up with the interview, but before the wrapping up, you have up to 5 minutes for a brief concluding statement. I would like to express my gratitude to the members of the expert group for such efficient and proliferal work, and separately, as I am interpreter, I would like also to express my gratitude to interpreters. I appreciate their interpretation and the quality. And in the end, I would like to support me. I would like to say glory to Ukrainian people and armed forces of Ukraine, and victory to us. Thank you. Thank you, Ms. Nataliia. We announced the wrapping up of the interview with the candidate Denysenko Nataliia Mykolaievna.